Okay, we have started the session, and again, thank you everybody for being with us this morning. There's a large number of people today, and I'm glad to see the turnout. And thank you very much for being a part of this conversation. This is the third in a series of presentations on the land code, and I won't steal the thunder from our guests today, Bill Taggart and Beth Armstrong from Fogler's Rubinoff legal firm. Our lawyers helping us to put this together. I'm going to get the session started in a good way, and I'm going to call on Chief Carr, if she would, to please open the session for us with a prayer. Chief Carr.
Manoka Jeb. Good morning, everyone. I have our tobacco here, and I'm just going to start us off in a good way and ask that feel free to join in those prayers with us and have those good thoughts as we move forward. But Ani Bojo Wawash Keshto Dem Megasekwe Dishnakas Lori Jaganash Michasagi and Nishnabe and Dao. Creator, I ask that we come together with good hearts and good minds as we have our discussions, and we bring in our ancestors throughout this so that we can learn and grow and have those discussions while thinking of those 7 generations to come. Miigwech.
Thank you, Chief Carr. Again, just to remind anybody who is there with their video on, it is a recorded session this morning. And if you prefer not to be recorded, as I said, please remove your video portion on the broadcast. So thank you again. With that, I'll turn it over to our presenters for this morning, Bill Taggart and Beth Armstrong from Fogler's Rubinoff. I know there are a number of slides to go through, and the opportunity for today as well at the end is to take as many questions as we can and hopefully address the number of issues and number of questions that are there for people. I'm just going to mute Tom for a second here. Done it. Any rate, if we could get going, I think it will be a good session today with a lot of questions to come, and I'm looking forward to the conversation. So Bill, Beth, we turn it over to you, and thank you very much for being here again on this early Saturday morning.
Bill, you're muted.
Some people would prefer that, but thanks very much, Jeff. So I hope my screen your screen shows our presentation properly. Is it okay?
Yes.
Great. So I'm Bill Taggart. I'm a lawyer at Fogler Rubinoff in Toronto. I practice nothing but Aboriginal law, and I've been doing that substantially since the Constitution was patriated in 1982. That was slightly before Beth was born, but Beth is a lawyer at Fogler Rubinoff in our Aboriginal law group, and this is her area of specialty as well. It's been a tremendous privilege for us to work with your First Nation in developing a land code, your first land code, and we hope today to carry on presenting parts of the land code in detail. I hope you had a chance either to attend the last 2 sessions we had on March 10th and 22nd. But if you didn't, those PowerPoints that we presented at that time are on the Hiawatha First Nation website, and you can download them anytime and have a look at them. In each of the sessions, we focused on different parts of the land code because there's more to it than we could profitably go through in just a single session. It would just be a wall of information. It's still probably a little bit of a wall of information because there is a lot in it. We've tried to break it down into digestible chunks to explain what's being proposed. So today, Beth, why don't you tell us what we're focusing on? Oh, there we go. Last time.
And as well, I believe those presentations were recorded and are accessible for members on the website as well. So if you want to go through those presentations as well, can. So as Bill said, on March 10th, we did the lawmaking under the proposed Hiawatha Land Code. March 22nd, we did interest and rights relating to Hiawatha land. And today, what we're going to go through is we're going to talk about enforcement of land laws. Then we're going to look at the dispute resolution process under the land code. And then the largest part of today's presentation, talk about advantages and disadvantages of moving to a land code system.
So in the evaluation of the proposed land code and whether it's right for your First Nation, you need a context to make that decision. And what we've recommended is that a land code should accomplish three things. The first is it should transfer land management to the First Nation as part of the sectoral approach to building First Nation self-government, which is rather than taking over, replacing the Indian Act wholly with some constitution of a First Nation. Instead, you move sector by sector, developing expertise and increasing your administrative capacity to get to the point in the future when you can take over other sectors. The land management sector is, of primary importance, I think, to most First Nations people, because there is a very special relationship between First Nations people and their lands. And other than language, perhaps for some First Nations, and spiritual matters, land is where people want to start from, and it makes a lot of sense to do that. So a good land code is going to transfer the current administrative functions with respect to land management that are the responsibility of Indigenous Services Canada over to the Band Council and the community and the institutions that the council and the community create to manage their own land. Those institutions that you set up and the laws that govern them, the rules that they operate under, have to be capable of being implemented within a First Nation that has fairly limited staffing, limited bureaucratic capacity. So they have to be clear, straightforward, and cover all the bases that are going to be necessary to put in place an effective land and an efficient land management system. The second criteria I think that you need to keep in mind when you're trying to judge whether or not a land code's a good land code is how clear is it? To what extent does it have ambiguity or leave questions open that would have to be referred to a court of law for a decision? What we want to do is make sure that how to do things is absolutely bulletproof, clearly stipulated in the land code, what can be done and what can't be done, the limits of authority of the council and the community, so that when a land law is passed and a dispute arises, if the First Nation has to go to court over it, the judge is going to find that the law is capable of being clearly understood and its requirements are clear and that it's fully enforceable. A lot of First Nations laws, in my opinion, are not enforceable because of defects in the drafting and the overall integration with the legal system that prevails in Canada. That's one of the things Beth and I have tried to focus on as a key component so that we can stand behind our drafting and say to you, if this gets to a court, a judge is not going to say, I don't know what this means, can't enforce it because it's not intelligible or it's not complete, or that it wasn't properly enacted. So there's a large part of the land code that actually deals with the process of enactment, lays it out step by step exactly how to do it so that it's straightforward and to follow, and there'll be certainty. And the third really important criteria, and maybe this one should have been at the top, is the land code should improve community life and it should facilitate development within the reserve. That's both residential development and commercial development, industrial development. It needs to facilitate those things in ways that that jibe with the beliefs of the particular First Nation, their orientation towards their limited reserve parcel and how parts of it should be used, what parts of it should be preserved for other uses, and how the environment is going to be protected. You can't do all of that in the land code because the document would get excessively long because that's a lot of work to do. But what you can do is lay out the framework for developing land laws that accomplish some of those tasks. And that framework should be designed so that it will be productive, will maximize community input so that council's not just going off on it on its own journey, but the whole community is behind it. We've tried to set this draft land code up that way. So with those three kind of criteria as the context, why don't we get into our topics for today? The first of them is enforcement. Beth, do you want to talk about what's in the existing, the draft land code?
Yes, so as we talked about on March 10th, we discussed the legislative authority of council. So in section 4.01, the land code says that council, on behalf of the Hiawatha members, may enact land laws relating to a variety of matters, including interests and rights or licenses relating to Hiawatha First Nation land, the development, conservation, protection, management, use, and possession of Hiawatha First Nation land, and any matter arising out of or ancillary to the exercise of that power. And as well, specifically related to enforcement, under that legislative authority, council may enact laws relating to enforcement measures, including power to inspect, search and seizure, and to order compulsory sampling, testing, and production of information. As well, if a land law is enacted with community consultation or approval, under section 4.03, a land law can create offenses that are punishable by summary conviction under the criminal code. Can also provide for penalties for those offenses, such as fines or community service. And as well, environmental laws enacted under this system must include punishments having at least the same power and effect as Ontario laws that are applicable outside of the reserve.
These same principles are repeated in the land code in the section that actually deals with enforceability. So not only does council and the community have the right to create these laws, which is the focus that Beth has now, the legislative section of the land code, but the enforcement section, which is in section 16, repeats these same principles. We didn't bother to set it up here, but it reads more or less the same way.
So in that section of enforcement, section 16, the land code also sets out fees and fines, and sets out that all fines paid on conviction of an offense are the property of Hiawatha First Nation. And as well, Hiawatha may deduct outstanding fine amounts from funds owed by the First Nation to the person who is liable to pay the fine.
Just before we go on, I want to say I noticed that Chief Kelly LaRocca has joined the meeting this morning. I wanted just to say hello to the chief and congratulate her on her very recent land code success.
Yes, thank you. Thank you, Bill. Hello, everybody. Thanks for having me. My apologies for my lateness, but there was a bit of a we'll call it a family emergency. Anyway, everything's taken care of, but thanks for having me, and I'll sign off. Well, let Bill take the floor.
Thanks, Chief.
And as well, in section 16.02, the land code allows for the appointment of enforcement officials. So for the purposes of enforcing land laws, Hiawatha First Nation may appoint its own prosecutors, enforcement officers, and justices of the peace. And in 17.01, the land code protects office holders from liability for performing their duties under the land code in good faith.
This is a really important provision because it's what's been a major barrier to the enforcement of bylaws passed by First Nations under the Indian Act. There's no such protection against criminal or civil proceedings against a prosecutor in the Indian Act. And what's happened is that where bands have gone to court to enforce banned bylaws, if the prosecution, they have to, first of all, Prosecution Services Canada will not handle those on behalf of First Nations. They've refused to. So that's forced First Nations to hire lawyers to act as private prosecutors of banned bylaws enacted under the Indian Act. And if those prosecutions were unsuccessful, it left open to the defendant to commence a counteraction against the First Nation and against the lawyer who acted as a private prosecutor personally for malicious prosecution, because he didn't have this statutory protection. And since the prosecution failed, it's sort of deemed to been a malicious prosecution. It should not have been brought. And in some cases, those malicious prosecution countersuits brought by accused people have been successful and awards have been made. So this sort of put a big chill in the legal community on enforcing banned bylaws. And one of the things you can do under a land code, specifically set out in the framework agreement, is in your land code you can provide protection from being sued for your justice officials, the ones who are required to prosecute and otherwise enforce land laws. So we've incorporated that. Oh, Beth, we got a scenario here. You want to go through this?
I do.
So
Okay.
just before you do, what we've done is to sort of give you a sense of what all these words that are been on the previous slides actually add up to. We sort of put together a make-believe scenario here. Nobody whose name appears on the screen is the person we intend. It's all fictitious, honest. And we just want to ask you, okay, you've seen what the land code says for the last few slides. What would happen? So why don't you go through this one, Beth, on enforcement.
Sure. So HFN adopts a land law under its land code with community consultation, which makes it an offense punishable on summary conviction to interfere with an Itsawawin site, a site of spiritual, historic, cultural, or other significance. Mike is seen using a metal detector near a designated Itsawawin site and appears to have collected several artifacts. Mike is not a member. Can Hiawatha First Nation enforce the land law against him?
So if it was a banned bylaw, I can tell you there would be a challenge. You might be able to get the OPP to, or your own police force to intervene, but actually succeeding in court would be quite a challenge. However, under the land code, it's going to be a bit more straightforward. First of all, the important point is that you can appoint your own enforcement officials with authority to search Mike and to charge him with interfering with an Itsawawin site. And then you can actually appoint your own prosecutor to prosecute Mike. And if it was necessary, you could actually appoint a justice of the peace. You have that power under the framework agreement to actually conduct the trial of the charge against Mike. Those are all brand new powers that weren't available to, except for appointing private prosecutors, available to First Nations under the Indian Act. And if Mike is convicted, he may be ordered to pay a fine to Hiawatha or to pay for the restoration of the site. That's because you can order restitution, or he may even receive a prison sentence. Okay, so that sort of covers, and I said I should have added all enforcement officials are protected from liability under the land code if they are doing their duty in good faith. Obviously, if they are not doing their duty in good faith, they wouldn't receive protection. So that's what we had to say about enforcement that's in the land code. We're pleased to handle any questions. Jeff, do you want to deal with anything that's in the chat queue now, or do you want to wait till if we go further into the presentation?
Well, there are a number of questions right now that have been posted up on the chat, but I think maybe what we should do for continuity's sake is leave them all, maybe Bill, to the end and try to cover them all at that point. If people wish to raise questions, put them on the chat. We'll try to pick them off as we go through, but probably better left to the end to allow you time to get through all this piece.
Okay, so the other topic we're going to cover this morning that's in the land code is, before we get to the advantages and disadvantages, is the dispute resolution section, which provides a way for band members who may have disputes either with the band council or with their other band members to seek a resolution without having to go through the court system, given that that is a very expensive and cumbersome process and is unlikely to give full effect to Indigenous values because they're not built into the Canadian legal system. Beth, you want to explain what's in the dispute resolution provisions?
Sure. So the dispute resolution provisions are all set out in section 12 of the land code, and 12.1 deals with what Phil just described. It sets out that provides for a voluntary process for the resolution of land law disputes. And there are certain exceptions of matters that can't be brought under this process, and those are set out in 12.03. And 12.2 sets out the two different available processes, and those are mediation, so discussions facilitated by a mediator, or binding arbitration. And in both cases, the person, the facilitator or the arbitrator, is appointed by council. And in 12.04, the code sets out how parties access this process. And in order to access it, parties must agree, the parties to the dispute must agree in writing to, first, what the dispute is actually about, second, who the parties are and who must be involved in this resolution process, third, whether they would like to use mediation or arbitration, and you can use both, but probably use mediation before arbitration, definitely. For council's authority to appoint the mediator or arbitrator, so agreeing to that authority of council. And as well, the parties must agree to participate in the process and then be bound by the outcomes of the process. And there are a couple powers of the mediator and arbitrator, two of which we've highlighted here. So the mediator and arbitrator may make an order requiring a party to the process, to the dispute, to pay the costs of the resolution process. And that's in 12.9. And in 12.10, an order by the mediator or arbitrator under this process is binding on the parties who participated.
Oh, look at this. We've got a scenario.
Right. Okay. So a scenario for dispute resolution. Nick, a member of Hiawatha First Nation, has a house on Hiawatha First Nation land and decides to lease his house to his friend Oliver. The lease requires the tenant to keep the land clean and tidy at all times. Oliver has been accumulating old cars to scavenge parts to keep his main vehicle going, and there are now several wrecks in the yard. Nick has asked Oliver to remove them, but Oliver has done nothing, saying the wrecks are mostly out of sight and he still needs them for a project car he is working on. Neither wants to go to court over this. What can Nick and Oliver do to address this dispute?
Okay, so under the dispute resolution section of the land code, then Nick and Oliver, if they agree, because it's voluntary, they can use the dispute resolution process to set out in the code. They have to jointly submit a request for dispute resolution to council. In that request, they have to sign off that they both agree on the four things that Beth accepted, or Beth set out previously, on the nature of dispute. In other words, a statement of what they're disputing about. And I guess in that case, it's going to be whether or not the keeping of wrecks on the property violates the terms of the lease. On the choice of either mediation or arbitration to settle that question, to accept council's appointed mediator or arbitrator, and to participate in the dispute resolution process, and to be bound by any orders or agreements resulting from the process. So unless they agree to all these four things, the dispute resolution doesn't go ahead. But once they've got, what's missing from here, and I apologize, I left it out, they also have to agree on who are the necessary parties to the dispute, because in this case, it seems like it's Nick and Oliver. There could be disputes in which there are other parties who are necessary as well. Like you might imagine a situation in which some of the stuff that's on the property was stuff another individual was supposed to have removed and never did, and the tenant may not think it's his responsibility to chase that down. He may think it's the landlord's responsibility. So there could be other parties that are necessary. And at the end of the dispute resolution process, whichever one they choose, either Nick or Oliver may be required to pay all or part of the cost of the dispute resolution process if the mediator or arbitrator makes that sort of order. And of course, there would be a, if it's just mediated discussion, the mediator in that case doesn't take a position on who's right or wrong. He just tries to make the parties come to a mutual agreement on how to solve the problem. Maybe Nick's going to get rid of 5 of the recs and only keep 1 or something like that. But if it's arbitration, then the arbitrator would have the right to make an order that would be enforceable. The order would ultimately be enforceable in a court of law if the party who the order was made against didn't comply. So that concludes the part we had to present on dispute resolution. We've sort of given you the outlines. You'll probably need to go to the land code, the proposed land code, which is on the First Nations website, and read section 12 yourself to see, for example, what kinds of things are excluded from the dispute resolution process. They're mostly things for which there is already a dispute resolution process, like housing allocations, etc. But by and large, almost everything can be set up can be brought to this dispute resolution process as long as all the parties agree. So we're going to move on to the second part of our presentation today, which kind of starts from a couple of questions. So you might say, okay, looks interesting, looks progressive, but what are the advantages and what are the disadvantages of going into a land code? This is our main focus for today. So what we're going to do is present an overview of the differences in land administration when you're proceeding as you presently are under the Indian Act and when you're proceeding under a land code. So what happens when a First Nation adopts a land code? Well, first thing is the power, the control, the responsibility for managing HFN's reserve lands is transferred from Canada to the First Nation. That means that 44 sections of the Indian Act which deal with land management will cease to apply within the reserve. They will be replaced by the land code, by land laws, policies, processes, and institutions that are created by the First Nation and that are informed by the particular Indigenous beliefs of those First Nations that adopt land codes. Which system's better? Well, that depends. It depends on the land governance and the development objectives of the particular community. The important thing to keep in mind is that the decision to adopt the land code is a final decision in the sense that the framework agreement and the First Nations Land Management Act don't provide a way back. So if you make the step of going to a land code, that's where you're going to be from this point forward, because there's no way back into the Indian Act administration system. So the decision has to be taken carefully with all things being weighed. I don't know, unlike membership management, I don't know of any First Nation that's wanted to give land management back. I apologize. So Beth, why don't you talk about what community-based land management is?
Sure. So also just what we've done is we've sort of set out pros and cons, and you'll notice that the pros that we're highlighting are in red, and the potential cons are in gray, and they're together on the same slide if they sort of relate to each other. So first, community-based land management. This means that Hiawatha's land code and land laws will replace the Indian Act's colonial land management system, as Bill was mentioning on the previous slide. And that system vests ultimate authority in the minister, whereas the land code system vests Indigenous culture-based system, which vests land-making powers and decision-making in the community and its elected government. And taking over land administration is part of the sectoral approach to building self-government, as Bill was talking about. This is taking over one sector at a time, and with the opportunity to grow in governance, effectiveness, and efficiency.
So that's the big pro of doing a land code, and I think it's what the motivation almost all First Nations start from. There are some cons associated with that, and whether they're cons or not is actually, you know, an individual judgment to be made. Some people would see them as cons, some wouldn't. But there is a reduction in federal responsibility. So it's a step forward in self-government. It's a reduction in the paternalistic system that applies to First Nations. But what it means is that when you bring your land code into effect, part of Canada's fiduciary responsibility to manage First Nations land, and that's the fiduciary responsibility that's embedded in those 44 sections of the Indian Act, which no longer apply within the First Nation. That fiduciary responsibility is transferred to the First Nation itself, to its council in the first place, but to the First Nation as well, because many things under the land code are subject to a community vote. So there is a reduction in Canada's fiduciary responsibility. It's not complete. Although the framework agreement contemplates total transfer of land management to the First Nation, the minister actually has a couple of strings that the minister keeps. One of them is a power, for example, to approve exchanges of land. Although the framework agreement says the minister, Canada has to approve the form of an exchange of land. That's where, you know, land is being given up in a reserve for a road or a transmission line or something, and in exchange, the First Nation is getting more land back, which is going to be added to the reserve. So that step still requires the minister's approval. So there is still some fiduciary response and paternalism still built into the land management system that hasn't been removed. So the second topic we wanted to deal with was land management tools. Beth, you want to address this one?
Yeah, so under the framework agreement, there's a broader spectrum of land management tools. And that's because the framework agreement permits First Nations to exercise much broader powers over reserve lands than are available under the Indian Act bylaw powers. And they're able to replace Indian Affairs decision-making on land management issues with council and community decisions. So part of the benefit of these broader powers is to give First Nations more direct control over their reserve lands, and as well allow the First Nation to respond to community needs and priorities, including things like economic development opportunities in ways and timeframes that just aren't feasible under the Indian Act system and bureaucracy.
So there is a downside to this, or it's not really a downside, but it's just something you need to be alerted to. And that is that because these 44 sections no longer apply, the land code doesn't fill all of them. It provides a framework for filling them all. And then so they're actually, in addition to doing the land code, as soon as the land code is adopted, the First Nation has to embark on a legislative program where it has to develop the new land laws on matters such as interest in land, what kind of interests are going to be created. Most important are three key things. One is a comprehensive land use plan. It has to be developed for the reserve to show what kind of development, what kind of areas are going to be preserved for residential development, where commercial or industrial development is going to be permitted. Which areas is it Wawin sites that have to be protected from any interference, any development? which areas are going to remain natural and those sorts of things, natural parts of the environment. That law gets developed through a very intensive community consultation process, and I've been through a couple of them with other First Nations, and it's not atypical for that process to take a year or even more, 2 years, because it is a very comprehensive look at the reserve and planning for the future. And it takes a lot of consultation with members to make sure that the land use plan is going to have full support in the community. You're going to do a matrimonial real property law, which deals with the interests of spouses in lands within the reserve, which they may hold under a certificate, either possession or allotment or whatever it's called in your land code, or if they are tenants or leaseholders. In the event of breakdown of a spousal relationship, who gets to stay there under what circumstances. That's also an intensive community development process and it's one in which a lot of Indigenous values that probably aren't part of the general Canadian public concept of spousal relationships, especially in relation to the rights of children, tend to be brought forward. A lot of the matrimonial real property laws that First Nations develop are very specific to the culture of those First Nations. And the third one is environmental stewardship. I think I received a question, and thank you for submitting the question. Somebody asked, because we had mentioned this point in one of the previous presentations, can't you do environmental bylaws that do everything you need to do under land code? Well, the answer is no, you can't, because the bylaw powers that are available to a band council under the Indian Act are extremely circumscribed. Under Section 81, they allow the band council to make bylaws about noxious weeds and a couple of other things like game on the reserve, but they don't deal with the comprehensive management of development such as environmental assessment, environmental permitting, and environmental protection. The latter in particular, because there is nothing in the Indian Act that allows an environmental authority set up by a First Nation to walk onto a development site and inspect to make sure the environmental laws are being respected, and to lay charges and to gather evidence and to prosecute those charges. All of that is only possible under a land code under the framework agreement. We call these things, which have to be filled by the First Nations own laws, regulatory gaps, because there's no regulation until the First Nation gets in place there, but the land code does provide governance solutions while these land laws are being enacted. For example, under the matrimonial real property, there is a federal statute that's in place that applies until the First Nation gets its own matrimonial real property law. With respect to land use, powers invested in council to make decisions about land use pending the development of the comprehensive land use plan. And same thing with respect to environmental matters. The individual agreement that the band will enter into with Canada to take over the land will include a preliminary process for environmental assessment. It doesn't deal with environmental permitting or protection, but those are things that you can do as ancillary under your land code, even if you're following the preliminary process that's set out in the individual agreement that the First Nation will sign. And a big part of the environmental stewardship laws will be to designate wildland sites. These are sites that are of spiritual, cultural, or historic significance to your First Nation. We've already, with Jeff, sort of looked at a couple of examples. Jeff, these things, several of them relate to wars in the region, right?
Sorry, Bill. Yeah, there would be sacred sites. There's also medicines and everything else in those areas that would be lands looked at.
Right. So those are things you need to consult with your elders about and to identify them properly. They need to be surveyed and located and protected in perpetuity. So that's what you can do. You need to fill these regulatory gaps. And unfortunately, I can't see this last point here. Can you see it, Beth? Because I've got controls over it, unfortunately.
Sure, I'll read it. So it says, developing these land laws will take money, community involvement, and time to develop and roll out.
Right. But as I say, there are interim processes in place too, so that there won't be any uncovered regulatory area in which there is no law applicable within the First Nation after the land code's adopted. Now we got a couple of things for which I don't think there are any downsides. Let's talk about increased transparency and involvement of members. Beth?
Yeah. So under the Indian Act, council may, with certain exceptions, enact bylaws without any input or approval from members. However, under the proposed land code, council is limited in the kinds of laws it can pass without community input or approval. So earlier we were talking about enforcement measures. Those, if there's an offense that's punishable under the summary conviction procedures in the criminal code, that has to be enacted with community approval or community consultation. And as well, under the proposed land code, there's a mandatory notice period. So the law that is proposed to be enacted must be available for members to look at 21 days before it's enacted. And all land laws must be published and registered in the First Nation Lands Registry and as well on the First Nations website.
There probably will be other ways that they'll be published as well. There is a special publication. It's called the First Nations Gazette, based out of Saskatchewan, in which First Nations publish laws for the purpose of anybody having noticed that they've passed laws. It's a really useful site for lawyers to go to when they want to know what the laws of a First Nation are. In addition, you'll see that under your land code, if you go to look at it, there is a new institution being created, which is a First Nation Land Laws Registry. This is run by a registrar, and it's a computer-based database of all the land laws that get passed by the First Nation, which is searchable by things like the land area, particular parcel of land you're interested in, or by topic. You want to find out if there's anything to do with wild dogs or whatever. This registry will also keep up to date on whether land laws that have been passed have been amended or repealed or replaced by new legislation. So it'll be a really good resource. And if you're ever interested in developing a parcel of land, you'll be able to go to the Land Law Registry and see what part of the comprehensive land use plan applies to it, what other land laws may have been passed with respect to that parcel of land. So you won't get any surprises if you want to proceed with planning to use that parcel. The other topic is increased accountability of Band Council. Go to it, Beth.
So under the Indian Act, council is accountable to the minister for land management decisions and technically to the members just for in the elections. But under the proposed land code, council is accountable to the membership. The council is required to obtain approval and input from members on certain decisions and must report annually on all land transactions in a special community meeting each year.
Right, so that community meeting would deal with what interests in land the Band Council granted during the year, what it did with the revenues from any resources that were developed, like forestry or gravel, or any lands that were set aside for community use, like roads or powwow grounds or new facilities, nursing stations, etc. So it would have both a interest in land part to the report as well as a financial part to the report. Oh, we got a scenario on increased transparency and involvement of members. Go to it, Beth.
So we're going to talk about this scenario and talk about how it would play out under the Indian Act and then under the proposed land code. So scenario is a delegation of HFN members ask councils to enact a banishment law. assuming council agrees to proceed, what further role will HFN citizens have in the enactment process?
Okay, so if we looked at the Indian Act, we would find that council can enact a banishment law under its Indian Act authority to enact banishment laws regarding trespass. And it can do so without community input or approval, just as up to council. And several councils have done that. And then several of them have been to court, and in almost all cases, those trespass laws have been struck down by the courts. Just because procedurally the council didn't go about it the right way, not because it wasn't possible. Now, under the land code, the process is in all land law enactments, council must provide a minimum of 21 days notice to members before it can enact a land law. And a banishment law wouldn't be any good if it couldn't be enforced, and it would have to be enforced under the criminal code and the summary conviction procedures. So for that reason, the council couldn't enact the land law, because the land law says that any land law that involves penalties has to be passed either with prior community consultation. That means the council brings the proposed land law to community meetings like we're having now before they enact it and gets input. And these meetings, I can tell you all these meetings we've had on the land code have resulted in changes to the land code to take into account issues members have identified, or a community approval vote. Either one would be satisfactory. And it's important to add to this, it doesn't follow necessarily from this scenario, but even if there weren't penalties, the land code says that whenever council feels a matter is controversial, it can submit a draft land law to community approval vote. So any draft land law can be submitted to a community approval vote. If the council perceives there's a difference in perspectives in the community that needs to be ironed out through this type of process, or that the council wants the law to have full community support before it's enacted. So I think the biggest part of we talked about it in the the three criteria for judging whether a land code's a good land code. And one of the main advantages of doing a land code is it allows First Nations governance model to progress from a discretion-based decision-making to rule-based decision-making. And this is major. So you want to explain this, Beth?
Yeah. So under the proposed land code, council actions and decisions in relation to land development proposals and the protection of the environment will have to conform with community approved rules. So those kinds of rules, for example, are the comprehensive land use plan and the environmental stewardship regime, which have to be developed under the land code and must also be developed with community consultation.
Notice that there's a little typo there that should be conform. I take responsibility for that.
So these rules reduce the role of discretion in council decision making. They're guided by the rules instead.
And the other thing we wanted to point out is, because the questions have been raised in the past, what happens to existing interests? You've got a lot of CPs within the First Nation. Is this land code going to suddenly take away people's rights who already have land rights that they acquired under the Indian Act land management rules? What do you say, Beth?
So all CPs, leases, licenses, and other interests that exist on the date that the land code comes into force will continue in effect and be unchanged. And if they were lawful before the land code, they will be lawful after. And once the land code is in force, all land transactions will have to follow the procedural parts of the land code, and any changes in an interest or license will have to conform to the land code and applicable land laws, such as the comprehensive land use plan or environmental stewardship regime.
Okay, so I think we have a scenario to deal with, cover some of these topics. Council discretion versus rule-based decision-making.
Okay, our scenario. Rebecca has a plan to open an animal rescue on HFN land. Stacy has a plan to build a bird sanctuary. Both Rebecca and Stacy submit detailed business proposals with a request for a grant of the lease of HFN land in order to open their businesses. Council approves Stacy's proposal, but rejects Rebecca's as not suitable for our community. Rebecca believes she has not received fair and equal treatment. Does she have a valid complaint?
Well, I mean, under the Indian Act, since the decision to approve or reject either of these proposals left wholly up to council, with no decision-making rules in the act, the process and the decision, despite the best intentions of council to be fair and equal, treat everybody equally, may appear to be entirely subjective and arbitrary, because there's nothing to point to and say, this is the rule we're relying on. And under the land code, immediately after the land code is ratified, as we said, the First Nation is required to develop a comprehensive land use plan, environmental stewardship regime, both with community approval, and which will provide written rules for deciding land development applications and objective criteria for making those decisions. So these steps will reduce the discretion that's left to council, because the rules about what lands get used for will be set out in black and white, and everybody will know what to expect even before they make their applications. That doesn't mean there won't be any council discretion after the fact. I mean, the rules can't cover everything, and there can be situations in which council decides that although something's compliant, it isn't appropriate for the community, but it will greatly narrow down the purely discretionary part of that decision making and bring it more into a modern rules-based model. One of the other areas that the land code will permit is the creation of new kinds of interests. Under the Indian Act, you only get certain kinds, but under your land code, you can be as creative as you want to be. To it, Beth.
So under the Indian Act, the model of certificate of possession can be replaced by Land Code First Nations with purpose-limited grants of exclusive use of land. So those purposes could be only for residential use, for farm use, or only for industrial or commercial use. And as well, as Bill was saying, more creative, applicable land interests can be created, such as designations for protected sites, or public use land may be created.
And one of the things that relates to land that's a big plus is that when a First Nation transitions from the Indian Act to a land code, titles in the First Nation are moved from the Indian Land Registry System under the Indian Act to a different registration system called the First Nation Land Registry System. This is important in a technical sense. It's very interesting to lawyers, may not be as interesting to the rest of you, but the Indian Land Registry System, which records CPs, for example, and leases under Indian Act land management bans, it's just simply like a deed box. It's just a pile of instruments that relate to a given parcel of land. You can't look at the record and determine which of those instruments is on title. There might be 20 or 30, which of them is currently in effect, which ones have expired, which ones should have been expunged. They're just all there, and everybody who wants to know what the current status of the land is has to read all those instruments and make all kinds of inquiries to see which ones are currently in effect and which ones are no longer in effect. And that system has created a huge number of errors. And it's not what's in place outside the reserve. Outside the reserve, you have systems that are either, a partial or almost complete, what we call a Torrens model, based out of Australia, which is a system in which the registrar guarantees that the registered instrument that sits on title as last registered is the governing instrument. The new FNLRS that will apply once you're under the land code, does have a priority of registration rule. So if two leases are registered against the same parcel, the one that was registered earliest in that sequence is the one that counts. The one that's registered later doesn't count. And so by registering, people can protect their interest from being overridden by some later transaction. We could give an example of this, but it would take us into a lot of technical detail, and I don't want to do that this morning because it's Saturday, although lawyers don't get weekends. But just let me say that this transition will be valuable to all of you because it will create greater certainty of claims with respect to title within the reserve, people who have rights within the reserve, and it will reduce the cost of doing due diligence to figure out who has what. Want to talk about advancement of economic development, Beth?
Sure. Under the land code, land management is faster and more efficient, which means that land code First Nation can deal with any economic opportunities that arise at faster pace or at the speed of business, as opposed to the slower speed of ISC. And as well, under land code, First Nations have direct control of land management and land use, which eliminates the role of the minister and the Department of Justice in matters such as leasing and permits. And this direct control and removal of minister and Department of Justice removes politics from commerce and provides certainty for outside business partners and investors that they're dealing with the people who have the direct control.
Yeah, so I have quite a bit of experience with this issue. I acted for another First Nation in a major industrial development that was going to have a minimum 20-year payback before, earn-out period, and it required a lease or a permit of the First Nations reserve. And the problem was that we couldn't get the Department of Justice to agree to a 20-year lease that had a predetermined rent for the whole of the 20 years. The rent escalated over the 20 years in the draft lease, but the Department of Justice wouldn't agree to it. They insisted that every lease had to have a 5-year open rent renewal, where the rent would change based on market value changes. So they weren't prepared to accept the judgment of the First Nation that the proposed financial arrangements were satisfactory to them, because I think the Department of Justice was worried that the minister might be sued by future band members for an improvident lease if it turned out that the economics turned against the provisions set out in the lease. That effectively killed the project because investors were not prepared to put millions of dollars into this industrial development if they couldn't predict over the repayment period what the lease cost was going to be, because it would have affected the ability of the project to repay its loans. And so just for that reason alone, that First Nation brought that reserve under the land code so that they could create a lease that didn't have a 5-year renewal. And they had that. They worked out the economics and they had that lease passed by the members by a community approval vote. And that has been an incredibly successful industrial development, transforming that band from one of the poorer bands in the province, probably to one of the richer bands, certainly probably one of the richest based on actual income from industry. So that's the kind of advantages that come from going under a land code. No longer is the minister have the whip hand in deciding what the terms of the lease for a project will be, and no longer is the Department of Justice there to say, no, you can't have that provision. You have to have this or that. So it's a big deal. Now, there is a downside to taking over management of your lands that we need to mention, and that's on the environmental management side. Currently, under the Indian Act, environmental management is handled by Indigenous Services Canada. And they don't do it under a particular piece of legislation like we have outside the reserves in Ontario, like we have the Ontario Environmental Protection Act and a lot of other statutes. There are dozens of federal statutes that relate to environmental matters, species at risk, particular types of activity like and various chemicals or other things that might be released into the environment, water quality and pollution and all those things. There's quite a spectrum of that legislation federally that applies on federal lands. The provincial legislation doesn't apply on reserves, but it is not a complete net. It doesn't cover all the necessary topics. It's not equivalent to the Ontario law. And the framework agreement says that if you go under a land code, you must develop an environmental set of environmental laws that plug those regulatory gaps so that the law within the reserve is at least as strong as far as protecting the environment as the law is outside the reserve, so that reserves don't get, to be waste sites or lands in which there's a sort of a Wild West approach to the environment. But that means that this task of managing the environment is also got to be taken on in addition to the task of managing the lands. And there's no doubt that the framework agreement does not provide funding for this particular activity in environmental assessment, permitting, and protection. Whereas they're covered now by Indigenous Services Canada to a certain extent. When you're under a land code, you're going to have to fund those things yourself. Now, for lots of them, you'll be able to negotiate one-time grants and budgets from Canada to cover them. If there's a major industrial development, and I talked earlier about a First Nation that did a major industrial development, in order to develop the laws that would apply to that development for that First Nation, I was acting for the First Nation. We negotiated $3 million in funding from Canada to cover the cost of developing those laws, getting them in place, and staffing the institutions that manage the environment for that project. So Canada, it'll just take an individual negotiation to handle any major proposal, but just to be alert that not only is land management going to be a responsibility, but environmental management as well. Because once you're in the land code, you're outside the land management, the environmental management system that's prescribed by that's managed by Indigenous Services Canada. I think that's a good thing, but it does increase the administrative tasks that the First Nation has to take on for itself. Improved enforcement. Beth, we've talked a little bit about this, but so I'll let you go through it.
Sure. So as we've mentioned, under the Indian Act, First Nation bylaws often go unenforced because there is no workable prosecution process for First Nation laws. But under a land code, First Nations can remedy this and appoint their own justices of the peace and special prosecutors. And such enforcement officials are protected from liability when conducting their duties under the land code. And as well, land code First Nations have the power to establish comprehensive enforcement procedures, including offenses that are punishable by summary conviction and providing for inspections, searches, seizures, fines, imprisonment, restitution, community service, and alternative means for achieving compliance with its laws.
So none of these things are available under the Indian Act. This is all brand new stuff, and it's a major advance in the recognition of the need to protect reserves, just in the same way that lands outside reserves receive protection. It's a major improvement. The bound side of it is the framework agreement does not include dedicated enforcement funding. You will receive an operational budget from ISC. Law enforcement's not a budget item in that budget, but you can use the budget for law enforcement if that becomes necessary. And I think if there was a major issue, then you could again go to Canada and say, we got this major issue, we need a budget for this, and negotiate on an individual basis. But the point is that if the costs of enforcement exceed the operational budget that's provided by Canada, that cost is going to have to be covered by the First Nation. So that's something you need to keep in view. I don't think that's a major hurdle, but it's one that we needed to alert you to. Inexpensive dispute resolution options. We talked about that this morning.
This is reiterating that the land code provides for a new community values-based process for resolving disputes between members. And it can be used by those who wish to avoid the expense of going to court.
Again, we got to note that there is fixed operational funding. So, you know, if these costs exceed what's available, cost overruns be the First Nations responsibility. And in addition, there are certain land management costs that are currently covered by Canada. For example, surveying, the legal work in creating Lockety leases, the appraisals that are necessary every 5 years under a Lockety lease to a non-member. Those things are going to have to be covered by the First Nation, or if First Nation's not covering them, then they have to be covered by, if it's a Lockety lease, for example, it's to be covered by the Lockety. Jeff, I think you told me that one good thing is surveying within your First Nation is largely completed or fully completed. Is that right?
Yes, yes, unless we're opening up other lands and doing other development. So the surveys aren't going to be an issue. And Wanda can confirm that for me. It was the question, and then we'll get to it at the end, that comes up here, has been raised a few times on the question and answer side, is concerns around the fees about appraisals, the fees about future costs, et cetera, that will have to be borne. It's a bit of misconception and a bit of confusion around that. So we need to cover that off
Okay. Yeah.
At the end.
Okay, we'll do. That's a good one to deal with. So we got a kind of a summary here, Beth, of advantages of doing a land code. Why don't you go through them?
Sure. So advantage number one, community-based land management laws. Second, broader land governance powers. Increased transparency and community involvement. Increased accountability of council. A transition to rule-based decision-making. There are new forms of interests, rights, and licenses. Improved registration and protection of members' rights.
Yay, oh, that's really good. That's terrific.
Speed up for economic development. Community control of environmental matters. Enhanced law enforcement options. Culturally appropriate dispute resolution process. And lastly, protection of pre-land code interests.
And just to summarize the disadvantages that we spotted going through: no going back, Canada's fiduciary obligations, the council's fiduciary obligations are increased, and Canada's fiduciary liability for land management is equally reduced. But that may be seen by members as a plus as opposed to a minus. And development of several key new land laws will be necessary to fill the regulatory gaps, and operational funding is fixed. So excess land management costs may have to be funded by HFN or by members. So Jeff, that's our presentation for this morning. We're glad to deal with the questions.
Well, thank you, Bill, and thank you, Beth, for that. We have, it's a lot of information and there's a lot of questions, and I'm going to try and get through all of them if I can. Can I get you to stop sharing the screen just so that we can sort of see people, and what I can do is I'm going to open up the chat area here and try to go through some of the questions that were asked by various people. Just give me 1 second. It started with a question that came in, and I know, Bill, you can see these as well, you and Beth. It started with questions that were asked about, and I've mentioned it just near the end there, around fees. The question said, will there be taxes if the land code passes? There are no taxes, period, full stop. There are no taxes. And so anybody who's telling you that there are taxes that will be charged, there aren't. We do have fees, and there are fees currently that are charged in the community, but anything, the whole question of taxes would have to come to the community. It would have to come to the nation to have a full conversation about the whole implementation, of taxes. But there will be fees, and there are fees right now, and we can go through some of that. But the question would be, Bill, then is, will there be taxes if the land code passes? Will chief and council have control over the land? These fit into a few themes. The themes around the whole issue of the issue of fees and taxes, the issue of council control and council dominance over what can be done, and the role of chief and council on the land code. There are other questions that were asked there by Kim that say, how will the board committee be put together? Will there be costs to the citizens for roads, garbage, and recycling? And then how does this affect the people of Loose Land? I think we've touched on some of those, but I'm interested to hear what your thoughts are on that. And we'll go through the rest of the questions as we go down the list.
Sure. You're right. Nothing in the land code deals with taxes at all. There are user fees in the land code. It gives the First Nation the power to deal with user fees. Will chief and council have control over the land code? The land code is a device that transfers responsibility from the minister and the department to the community and its council. There are roles for council and there are roles for the community in developing land laws. And but yes, it is true. The main council has full legislative authority, subject to the checks and balances that we talked about. They are the legislative body. They are also the executive body, so they are responsible for implementing the land code. And there are checks and balances on that to make sure they do it in a way that conforms to the community. And they are responsible for prosecuting violations of the land code that will ultimately come to the council as well. That's the whole design, to replace the role of the department in land management with the First Nation and its council, assuming all those responsibilities.
So to that question, Ashley asked, if Hiawatha puts in a land law that the citizens disagree with, what can we do? You talked before about the process by which land laws are created. So if Hiawatha puts in a land law that the citizens disagree with, sounds to be, well, the citizens need to agree with it in order for the land law to be put in place.
That depends on the topic. If the topic is a major one that affects community life, it's likely to require community input or require a community approval vote. If it's just a procedural matter, then it falls within the jurisdiction of council to proceed that way. If the community members thought that council had passed a land law, regardless of what the topic was, that they didn't agree with, the land code provides members with the right to introduce their own land laws. They can put together a land law proposal. The land code sets out the 4 important elements of the land law proposal. They're very simple. I think when we did the presentation on members doing land law proposals, I showed that you could do it on a napkin, if you recall, and you can present that in a council meeting. Obviously it's still up to council to decide whether to proceed on the basis of members' land law proposals. They are, after all, the elected body, whereas the members are not elected. I mean, they are members because they're members of the First Nation. So ultimately, the accountability of council is still going to be through the election process. If the land administration of the council is not satisfactory to the members, then I would expect to be a new council the next time there was an election. But to make sure that all these issues have a profile and the community is fully aware, the land code has built into it this accountability process where every year the council has to come to the community in a special meeting saying, okay, these are the laws we passed. These are the transactions we approved. This is what we did with the money this year. You know, we have a surplus here. We have a deficit there. We're covering things off this way. And that then leaves it up to the electorate to decide if they're satisfied with the administration of the community by the current council. That's the accountability mechanism that's built in.
The counter question that Ashley also asked, and I'm just going through these questions, by the way, everybody that were asked on the chat list, that if the Canadian government puts in the land law that the citizens disagree with, that's already answered. Once this transfers basically to Hiawatha, government of Canada isn't responsible for instituting land laws on Hiawatha.
That's correct. I mean, any bylaws that have been passed in the past by a council before going to a land code, before the community goes to a land code, they continue to apply until they're either repealed or replaced by land laws. Land law covering the same topic automatically repeals the bylaw. And to see the next question, which is a good one because we didn't deal with it today, is how will the board committee be put together? Well, there isn't a board committee, there's council, but council may create boards or committees to manage certain things. Like, for example, if council puts together an environmental stewardship regime, it's bound to have an environmental department or an environmental panel that decides whether not to advises council on whether or not to grant permits and so on. All of those committees are appointed by council. That's the way it's set up in the land code. Will there be costs to citizens, i.e. roads, garbage, and recycling? The costs will be the costs you have now. The land code doesn't create any new costs, just recognizes that there can be user fees for services. How does this affect people that lease the land? As we said, existing interests are grandfathered in. They are treated as lawful after the land code comes into effect. If they ceased and there was to be a change in the use of land, that would be something that would come under the land code. You'd then have to follow it. The only parts of the land code that will apply to existing CPs, leases, licenses, permits are the procedural parts, the things that say you have to register your interest in the First Nations land registry system. It has to be in writing. If you may have to give notice to the band council if there's a change in tenant. Council doesn't have any approval power over with respect to lockatee leases. There's nothing in the land code that deals with that. It just says that because the First Nation has to know who has rights to reside on the land, because the land code deals with who has the right to be on the land, who has the right to cross it, then you have to keep the council up to date on who the tenants are on any lease so that they don't improperly bar somebody from coming on the reserve who has a right to be there, that sort of thing. So I hope that addresses
I think the last two questions for Ashley I'll answer the first one. The second one said that what benefits do we lose if we vote yes on the land code, et cetera. I think your slide where you did the advantages, disadvantages, et cetera, I think hopefully answers some of that for Ashley. The question she did ask was around the capacity to take this on. That question's been asked before as to whether or not there'll be funding available to do this. That clause or that condition is covered in the individual agreement actually that we signed with Indigenous Affairs. It provides funding for us on a 5-year basis. The funding is escalated annually through a formula that ISK has prepared, and every 5 years that funding is revisited. Now, I know in the past somebody has said, well, in 5 years, there's no guarantee you're going to have any more money. Quite right. In 5 years, there's no guarantee when our block funding ends through Canada, that Canada could come along and say, you're not going to fund that anymore. Canada comes along on a regular basis and says to us things such as, we're cutting back on your funding for post-secondary education. We're cutting back on your funding for health. We're changing the funding formulas with respect to a variety of other programs or services. That's done regularly, and we have to deal with that. But with the land code, what we've got is we've got a regular and an annual source of funding provided to us from ISK. In the first 2 years is a $75,000 add-on from the Land Advisory Board through the FNLMA. There is also the return of our monies held in trust in Canada, which equates to around about $260,000 currently, and that money is returned to Hiawatha as well. Will there be costs that we may have to incur ourselves at Hiawatha? Yes, exactly. And as Bill talked about, there will be legal costs for things like creating new laws. There may be some legal costs for challenges and those kind of things. At council, we'll have to figure out how we finance or fund those. It may be done through things such as part of our regular annual budgeting process, looking at how we use the investments coming out of the trust and use some of the trust investment return to be able to help cover the cost of any major expenses we might be incurring as a result of this. But we do have the capacity. There was a question asked later on about sectoral self-government, and is this sectoral self-government? Or is this a step towards self-government? It is sectoral self-government, definitely. It's pulling out sections out of the Indian Act. It's taking over and transferring care, control, and management to the First Nation to look after these items. So yes, it is in itself a self-government initiative. Is it a step towards full self-government? Hard to say. That's the nation's call, not what we're talking about here. We're not talking about the full transfer of all parts of the Indian Act and a full-out self-government initiative. The self-government initiative that was done in 2000, 2002, I'm trying to remember the year that it was done, roughly 20 years ago. I know at the time I voted against self-government at that point in time because Hiawatha did not have the capacity to be able to take on the whole governance responsibilities required under the whole self-government initiative. I believe we have the capacity here now. We have the capacity within our staff. We have the capacity with the funding that's provided, and we have the capacity that comes through the land code and through the involvement of the citizens of Hiawatha to be able to make the land code work. So yes, it's a sectoral self-government initiative, but it's not a step towards full self-government. That can only be done with engagement and full discussion at the community level. There was a question asked about our enforcement officials that Bill, you mentioned, where we could use our current officers, et cetera, or is this a new position? Hiawatha has police officers already in the community, and we have a policing agreement with the OPP. Are you suggesting that enforcement officials are new positions, or are these something we can use locally?
No, yes and no. The current police officers would continue, I hope. You're very, it's a tremendous advantage to you to have that policing agreement and to have officers in your community who are going to enforce and investigate and lay charges. What you're able to do is to appoint prosecutors, in other words, someone to take a charge forward and prosecute it in a court of law on the First Nations behalf. That's a new position. The Framework Agreement and the First Nations Land Management Act, by which Canada actually ratified the Framework Agreement, both speak to the ability of Canada and the First Nation to appoint a justice of the peace, in other words, a judge, to decide land code, to do land code trials, as opposed to taking it to the regular court. There are a number of there's a couple of very well-respected First Nations judges who have retired. There's many Indigenous people, lawyers who have retired or who might be willing to be Justice of the Peace. Justice of the Peace are not always lawyers. Sometimes they're just people with tremendous good judgment. No land code First Nation in Canada of the, I can't remember how many there are now. I think in force, so maybe Chief LaRocca can remember how many there are. I think it's 87 that are in force at the moment and 100 and some. Beth is already Googling. I can see her fingers going. But none of those First Nations have yet appointed a Justice of the Peace. And it would be quite an undertaking for one First Nation to do. But it's something that Mississauga First Nations might want to consider doing collectively. Am I right about the numbers roughly, Chief LaRocca?
Yes. And I'm just going to confirm with Cassandra. I think she's on the line, and Cassandra, if you want to put it in the chat even.
Yes, for sure. I'll put it in the chat. We have across Canada, coast to coast, there's 99 First Nations who have ratified their land code.
Okay.
That's right.
And just in Ontario alone, we have 21.
Great. So
for 100. That's right.
Yeah. So in response to Sheila, if that's who asked the question, it's a great question. There will be new positions as well as the existing positions will continue.
Thanks, Bill. There are other questions that come that have to do with user fees and charges, et cetera. And I think it gets captured in the one that Glenna has asked. What will this cost landowners in the end? I think you've covered it, but just to reinforce it, those who currently hold locate leases, those who currently hold their lands or whatever, there are no hidden charges or fees or anything like that coming through the land code. It's what's currently in place.
Yeah, and I mean, as we have, out of the interest of making you fully informed, we've said that the budget that's negotiated with Canada, Jeff has talked about a 5-year cycle, it's a fixed budget. So if your costs run over in a 5-year period, that may be an issue that you have to address yourself. But, obviously, if you're undertaking a major project such as the development of a comprehensive environmental stewardship regime, I think that's a good opportunity to make an application to Canada for one-time funding to develop that, because it would be an expensive process to do.
Right. But at the end of the day, the money, it will still continue to flow, as it were, on the formula basis to us from Canada as part of the land code. We get that every year. We'll continue to get it every year, and it will be based on whatever the 5-year formula is that they have in place. Yeah,
I mean, I think the answer to the question that Glenna has raised is really that what's changing here is the governing authority. There isn't a lot of change when the land code comes in the laws that apply. That does change over time, and it's a much more effective, efficient, and powerful land management regime that the First Nation is capable of putting in place. And but those things are done with community input and community approval in certain cases, depending on the subject matter. So it should be, going forward, the land management regime would be one that the community stood behind and put in place. We've also built in some protection for mistakes, because mistakes can be made, and land laws can be repealed in the same way they are made. We've even provided like a shortcut where a land code gets enacted or a land law gets enacted that needs a minor amendment that's, that doesn't actually change the content of the law, but changes some uncertainty in it or how it's expressed. If it doesn't substantially change the law, then there is a very straightforward way to make an immediate amendment through the Band Council resolution. If it changes the substance of a land law, then it has to be amended in the same way the land law was originally created. So if it was created with community approval vote, then you have to have another one. If it was created with community input, then you have to have more community input before doing the amendment.
Yeah, I'm just sorry, Bill, I'm just scanning through some more of the questions as you're talking. So, and I know that Chief LaRocca is on the call as well, and there may be opportunities where if she wants to jump in on some of these to describe what is happening in her community. But I'm just, bear with me, each of you, as I go through some of these. There was the question about, and I believe have answered it, but I just wanted to dwell on a bit more. It talks about responsibility for appraisals, surveys, et cetera. We talked about that earlier. At the end of the day right now, Indigenous Services under the Indian Act is paying for the appraisals that are being done on the leases. With the transfer to the land code, ISK will no longer obviously be providing those funds for the appraisals. And so the decision would have to be made, does Hiawatha continue to pay for those appraisals, or does the leaseholder, the locatee, decide that they are going to get the appraisals done and pass that cost through to those who are the leaseholders, to those who are renting the property. In normal situations, that happens. The landlord passes the cost through and rental charges to the individuals. Those would be done every 5 years. It's an opportunity actually under the land code to be able to open up those leases and have a look at them and revisit them and to see whether or not they are keeping pace with the current market and everything else. So I think that's something that we as a community are going to have that conversation. Do you want Hiawatha to continue to pay for those appraisals now that ISK is when ISK is not in the picture? Or do you want those costs to be passed through to the lessees who are taking on the property and leasing them? Chief Carr or Chief LaRocca, I see that you're maybe wanted to jump in on this. You just hold your hand up for me too if you need to. I can see you on the screen.
I just didn't want to interrupt. I wondered, just looking at one of the questions in the chat around 5360 funding, Jeff, could you or someone from Hiawatha speak to that, and then perhaps Cassandra and I can speak about the funding?
Okay, sorry, I think Wanda is on the phone right now, and I don't know the exact amount
Sure.
on the call. I don't have the exact amount. But Wanda, are you there now and can be put a figure on 5360?
Jeff, I can speak to that.
Okay,
Under 5360, HFN currently receives $54,644 for the lands department budget. Under FNLM, HFN would be receiving $280,508 for 2001 to 2002, which you can see in the individual agreement on the HFN website.
sorry, you 2021, you mean you're at 2001 or 2021?
Or 2021 to 2022, sorry.
Great.
Right, but is that current 5360 funding? Sorry.
Yes, the 54,000 was current 5360 funding.
Right, so that's what we're getting now is roughly $55,000 for the lands department. Under the land code, the funding becomes 280 basically and change.
Mhm.
Is that correct?
Yes, it is.
Thank you. Okay. So there's your answer, Chief. We go from 55,000 roughly to $280,000 on an annual basis for funding for our lands department.
Yeah, I mean, I knew it was a significant jump for Scugog. I assumed it would be for Hiawatha. I just wasn't sure exactly what you received in 5360 funding. Cassandra, I don't know if I could maybe Cassandra and I will kind of tag team a few comments. If you want to start on the more nitty gritty of the funding, Cassandra, and then I'll just give some remarks from Scugog's experience.
Maybe I should just introduce Cassandra. Cassandra is a technician with the Lands Advisory Board who has been helping work with us here at Hiawatha in putting the land code together. She was involved at the very beginning of this discussion and has stepped away for a while, I think, to deal with family and raising family, and now she's back. So we'll welcome her back, and nice to see you again, Cass. So just for everybody who's wondering who Cassandra is, she's our lab technician.
Thanks, Jeff. I thought everyone knew her.
I've been around enough, right?
Yeah.
So yeah, maybe I'll just kind of recap just the quick little discussion on the funding that was just mentioned. So your amazing lands department there did just provide the numbers. So currently under the delegated 5360 land management that Hiawatha does right now, you receive $94,644 annually to manage your lands. After 40,000 of that is transferred out as an expense and allocated towards membership, you're left with an operating budget of $54,644. So when transitioning to land code, a lot of factors come into determining what your funding level is, which includes take a look at all the transactions that your community currently does and over the last 3 years, which includes permits, leases, mortgages, your population, your land area, the environment, land use planning activities and whatnot. And that all goes into their funding formula, and they've determined that Hiawatha is a Category 1 funding, which amounts to $280,000 annually this year and would be prorated for the number of months that you'd be operational if ratified this year. And then that continues with a 1% inflation rate each year after. And there was a bit of chat about like just the 5-year funding block. So the funding arrangements are negotiated on behalf of all the First Nations at the direction of all the First Nations who are signatory by the Lands Advisory Board. And those discussions are ongoing. So we don't get to the end of a 5-year block and it just gets cut off. So since the beginning back in 2000, when communities such as Scugog, Georgina Island, and oh my gosh, I'm having a brain fart moment.
Grandma?
Whitecap, Dakota. When they first ratified their land codes, the funding amount was very, very low. I believe it was $85,000 annually. Now we've seen only increases, and we've never seen any reduction or stop in that funding amount. So I don't know if there's any further questions or anything, but I'll just kind of pass that back over to you, Chief Alaka.
Chief, you said you were playing
Oh, you're
tag.
muted.
She's muted, so
I
that's.
have to do that at least once in this meeting, you know, this Zoom meeting without talking to yourself. Anyway, hello, everybody. I just want to say thank you very much. I'm honored to be here, part of your community meeting. I realize how important these meetings are. Certainly, we've just been through a process where we've updated our land code, and yours is looking very, very bright and shiny and new. Kind of a new and improved version of the template that was floating around in the Lands Management Resource Center for 25 plus years ago. But, you know, lessons learned, and certainly land codes are what I like to refer to as a living document. They're basically like a constitution of your First Nation. It's your motherhood law, basically, which extends from creator based on your inherent self-governing authority as First Nations, Indigenous peoples to this land and this space. So what I love about it is it's a document that is born out of an iterative or discussion-based process of your membership, and is subject to change, quite frankly, because as much as people like to think lawyers are scientists and exacting, lawyers are really artists, right? The more exacting they are, the better. Certainly, we want exactingness in the way we draft our laws, but you can never cover off every situation in life. Certainly, we never thought we'd be faced with a pandemic. These things happen, you know, things happen to change, needs change and laws change on that basis. But I can tell you that this land code process will bring you greater transparency as a membership. Not that you need it, but you've got a great council, obviously. Chief and councillor are fabulous, and you've saw fit to re-elect them all, and that's amazing. I think that this land code is going to give them, quite frankly, a greater guideline in their governance decision making, and it just benefits everybody. Certainly, it has from Scugog's perspective. I want to just note that you know, I think the Q&A has gone really well. I hope everyone's questions have been answered through the presentations, through Bill and Beth and Jeff primarily, and Cassandra. So I more want to talk about Scugog's experience, because, oh, sorry, I just checked my 5 out of 25 over the past, sorry, 5, yes. My recent chat answer to Georgina, it's actually 7, sorry, correction. I just checked with our ED. I just want to make sure my 5 over 25 is right. In fact, I was wrong. It's 7 communities out of 25 years. But anyway, speaking about Scugog's experience, when we went into lands management, we basically went into it to facilitate a long-term lease of our casino, or for our casino, to enable our casino. If we didn't enter into lands management, we'd still be waiting on ministerial approval for a casino. It would never have happened. It, quite frankly, never would have happened. And all of our community feels that way. You wouldn't find a past chief or council member or community member who wouldn't feel that way. So we ended up getting the casino, and that was amazing, of course. But I can tell you that at the time, the way that the status and membership provisions of the Indian Act worked, our community was, I think, due for, according to our demographic study at the time, we were headed towards no members by 2031. No, sorry, 2035. Because our community was so small back then. And so, there's like, I think it was like 18 people living here in the community at the time, and it was a cornfield. And, did we have capacity? We question that certainly as a community, whether we had capacity to enter into lands management and do the work required. And, I guess, pardon the pun, we took a gamble on ourselves. Certainly we had more than 18 members in our total population, but most of them were living off reserve, many of them out west. So we didn't have a lot of capacity built within the community to deal with this stuff. But we, quite frankly, muddled through. We didn't, I think our first law we passed, of course, the land code we passed, and then we passed a matrimonial real property law, which is woefully outdated. It basically said, sorry, MSIFN members will have to go to the courts in the event of a dispute. So that was our MRP law. And then we passed a dog law. And then all of a sudden there were no reserve dogs running around loose. It's funny how that happened, but it actually worked. And that was our third big law. Then we passed a non-smoking law to basically abide by the new Ontario regulations, and we wanted to support that position on non-smoking. So we did pass that, and that's basically what we did for years. Because after we entered into the lands management and passed our land code, we really just worked on funding our community education program and trying to address elder care and healthcare needs. That was what we focused on as a community for the first 10 years after entering lands management. So, you'd think, well, that's kind of odd. Like right now, I'll be honest, Scugog is just into its, I'd say, second iteration of its land use plan. So that's been a slow going process, right? Super slow, but we're inching towards it. Why are we inching? Because it's controversial, because it's hard, right? But that's okay. It's done nothing to take away from our funding, to take away from our community. We're all still making decisions around lands management like we have for millennia. I think that's an important point. We can't forget that First Nations have been the environmental stewards of land, not just reserve land, but of our traditional and treaty territories since, time immemorial, as we say. And so why this is such a scary notion? I mean, I understand change is hard, but to take away having to go knock on the minister's door for every permit, lease, license that you want to do, I mean, that is really, I think, the number one goal is to assert your self-governing authority. Obviously, that's a point of pride for our people. That's a point of identity for our communities. But then secondly, it's not having to go knock on the minister's door. That is going to give you so much more freedom as a community. And I can't emphasize that point enough. But really, people make the assumption, well, Scugog had a casino, so it must have just had all this time and money to do all this lawmaking. Like I said, we passed a smoking law and a dog law and a pretty quick MRP law, and just focused on community wellness. Really, that was what we felt was most urgent for our people. And building housing, which of course we were funded for through CMHC. And that's what got our population up in the end on reserve. But, Now we're in the second iteration of our land use plan. We're going to be looking at zoning as well in that second iteration of the land use plan. We are looking at an environmental protection regime. We haven't done all of that work yet, right? Which, you know, again, we work as a community to take care of the lands that we have, right? If there's you know, we have two gas stations on site. We have a smoke shack. As many of you know, have been out here to Scugog. We have a Tim Hortons and a store. And you know, if there's an environmental issue, we know who does business in our community, and you know, we take care of it as a community. And the Moccasin Telegraph is really what protects the community at the end of the day. Right? That is still the way. That doesn't change. Your cultural ways do not change. I can't emphasize that enough. You know, as much as I no longer live in the middle of a cornfield and the face of our community has changed, I can tell you that our people haven't, and our culture has only gotten stronger through taking care of our lands ourselves. That was a big point of pride for Scugog, I can say, because we really, you know, we lost the language. Our last language speaker passed away last Christmas, actually. So we're in a cultural crisis, but in a way, as sad as that truly is, and we'll never get that back fully. I can tell you that our culture is stronger than ever, in a sense, since entering into lands management, because it's really given us the opportunity to look at, you know, how do we learn from our land, and how do we focus on community health and wellness from a cultural perspective. So we've really, I'd say we're stronger in our culture than ever on some level. Sorry, I see something in the chat from Georgina.
We're getting close on time, Chief LaRocca, so I wanted to turn it over to Chief Carr before we end. So,
oh yes, she's the chief in this room. Sorry, Georgina writes, just to confirm, Scugog generates per annum through its charity casino. Yeah, so that does not all come to Scugog. I sure wish it did. It never did, and it doesn't now. So under the previous charitable agreements, which have nothing to do with lands management, by the way, I mean, the getting of the casino had everything to do with lands management, getting that lease that was long-term, but the actual casino operation itself has nothing to do with lands management. But I can tell you, out of that 225, a tiny fraction of that actually comes back to the First Nation. Let's just say the House always wins, and the government is the regulator of that. So yeah, that really has little to do with anything, Georgina. So I'm sorry that you might feel that way, but I can attest wholeheartedly, fully, God's honest truth, Creator, strike me down. It really has nothing to do with having 225 billion in a casino, but thanks. So I just think it's important to note, you know, you guys you're ready. Why? You're already entrepreneurs. You're already land stewards, and you already govern your community in a way that is in the best interests of your families and your youth and your elders. You already have those tools. You already have educated people. You have a solid workforce, and you have a great chief and council. You have people in the community who are dissenters. That's needed in any government. We have them too. Every First Nation does. This is not a bad thing. So this is what is going to keep your governance being good and transparent and effective. None of that is going to change through lands management, but you will have greater self-governing authority. So with that, I'm going to congratulate you on your journey towards lands management. If I can be of any service, please let me know. I will definitely be there for you as a community. Scugog will be there for you as a community, because I think that I think that's important to support you as a community as you go through this. And we do a lot of sharing of documents and laws and things like that. Heck, we even share lawyers. So, you know, there you go. We will be there for you in this journey. So with that, I want to thank Chief Carr and her council for inviting me, and thank you for listening to the members. Miigwech.
Thank you, Chief. There was one, I will do this. There was one person that wanted to say something. I'll do that, and then that'll be the last speaker we'll take before I turn it over to Chief Carr and allow Chief Carr to offer some closing remarks. So Debbie, you said on the chat that you wanted to say something to me in regards to one of my answers. I think you can, I'll just make sure here that you're unmuted. Once I find you, there you are unmuted, so go ahead.
So one of the questions, the first ones you answered was in regards to being taxed for the land. In the very first meeting we had in the lower hall, when we had quite a few people attend, the only time so many attended with dinner, we went up to our land officer, Wanda, and asked her directly if we could be taxed for our land. And her answer was yes. So now it's changed? I don't know.
Well, I'm not sure what the conversation was or what she said in return, or maybe what you misunderstood.
I didn't misunderstood.
Oh, sorry.
There was other people standing there instead of me that heard it.
No, I'm not sure if, I'm asking if Wanda misunderstood. Yeah, I can't speak for her. But as we've answered tonight, there aren't taxes applicable under the land code. There will be fees, and those fees that are currently applicable would transfer over into the land code, the current user fees that Hiawatha charges for the lessees. But the lands themselves, if you're talking those CP holders, et cetera, there are no fees or taxes that are charged to the TP holders. If that's what was meant, there won't be taxes. So I'm sorry if that was the perception. I'm sorry if that was the answer that you were given. That was maybe a question Wanda didn't understand. I don't know, but I think we've clarified tonight, or to this morning, sorry, that there aren't taxes to be charged for the CP holders. There would be fees available to, or required for the locatees, et cetera. Sorry, the land, the lessees, the cottage owners, the cottage holders would be paying user fees, but there won't be any taxes. So I think we've answered that.
Jeff, I can add something to what you said. Just because I can't think there is a misunderstanding. Under the Indian Act right now, band councils can enact taxes. Your First Nation hasn't enacted any land taxes. That's not going to change under the land code. That it's there now, and it'll be there after the land code is in effect. There will still be that power, but the land code itself does not impose any taxes or create any taxes. The only thing it provides for is that there can be user fees for things like water, sewer, whatever is being provided, garbage collection. But it doesn't provide for taxes. The taxes are not discussed in anywhere in the land code at all.
Thank you, Bill. Okay, Chief Carr, I'm going to turn it over to you. I'm just making sure that there you are, that you're still with us, and I'll get you to unmute and then leave some closing remarks to you. Chief Carr?
I'm here.
There you
All right.
go.
Thank you, everyone. I'll just have a few words in regards to the conversation today, but the conversations I've been hearing of going along in regards to the land code. So I have written up some of my notes, so don't mind me from reading from some of them, but I didn't want to leave anything out, and hope that the questions you had today were answered. And if you have more questions, please put it out to Kelly, to Wanda, but Kelly is the lead, or Jeff. And just so everyone knows, Kayla, Councillor Howard, she is the new portfolio for lands. And so she's working with Jeff to get caught up on some of these issues and work that we're doing under the lands area. And there was some questions around, and I heard from them before, but I just wanted to let people know that this process has been ongoing since 2016. It was first implemented or started, I should say, or initiated by the previous council in 2016. And from there, there have been several meetings and information that's been sent out and posted. And the land code is important for Hiawatha's future because it functions outside of the Indian Act. So I did hear the conversation of this isn't self-government. This is us working towards taking care of our own lands further. It's a step away from the ministerial interference, and it will be a statement of our community that Hiawatha is committed to getting out from under the Indian Act. All our citizens will create the laws through the discussion-based process and ultimately vote on that. That's not chief and council, that will be our citizens. This is a hugely important piece as the laws will be borne by the community and therefore brought into by you. Hiawatha has been under 5360 for 30 years, which deals with management of reserves and surrenders of lands. And the minister or a person appointed by him for the purpose will manage or sell absolutely surrendered lands or manage, lease, or carry out any other transactions affecting designated lands in accordance with the Indian Act and the terms of this surrender. So this gives little control over the reserve land management. However, going under 5360 over 30 years ago, it met the need at the time. And even 30 years ago, it showed the proactiveness of our community wanting to be able to have more say over our lands. Yet with our growth, with 5360, we still have to have enhanced consultation with the Minister of Indian Affairs with respect to lands issues, and which are all subject to the Indian Act. We have outgrown the 5360. And the land code is another step towards taking care of our lands, managing the land, and ultimately lands management starts with the presumption that the community is capable of managing the stewardship and governance of its own lands outside whatever a Minister of Indian Affairs might think is best for Hiawatha. Through the lands management, Hiawatha will be opened up for opportunities to benefit of the community in a measured, responsible, and transparent fashion. Once the land code is passed, or if it's passed, it will trigger the development of land laws. Again, these land laws are all developed and passed by you. This will ensure responsible development driven by the community and will protect Hiawatha lands and waters. As First Nation peoples, we've always been responsible for the lands and environment protections. This responsibility was given to us from time immemorial. The Government Indian Act took this from us, and they do not protect us from this now. Hiawatha will develop its physical and legal structure over time. It does take time to do this, and we want to do it right. And we want to ensure that when this process is completed, you know, I can't give you an exact timeline. It could be 2 years, it could be 3 years, it could be, you know, but that depends on our community and how we work through this and how we pass these laws, develop and pass these laws. But it takes the time to thoughtfully develop the laws with multiple opportunities for community surveys, legal drafting, consultation and engagement, and voting. And the land code is a first step among many that are needed to shape our community into what we want most it to be for our collective future while protecting what our community holds dear, which is our lands and waters. Not one, and as you heard earlier, not one community that's under FNLM is looking to return to the Indian Act. And what you don't see or know is that we have citizens come to us all the time, whether it be to council, to the lands officer, they come to us all the time with issues and concerns that they have either with their neighbors, with right-of-ways. We hear this all the time. And of course, you're not aware of that. Or maybe if you've worked in that area or you've been on council before, you would have known that. But while lands management isn't the coverall for every community problem and issue, it is a starting point to something that is better to suit our needs in the long term, and it's created by you. Within this framework, the laws under the framework are created and approved by the citizens. And as we continue to grow, the laws get reviewed and changed to meet the growing needs of our community and those yet to come. And as Chief LaRocca noted, they've just been reviewing theirs. Council's only authority is to carry out the laws under the land code. Any new council may change the land code through the amendment process, which also goes through the community. And INAC has never fixed any legacy issues with the lands that we might have, and they will adequately fund us under the Indian Act for lands issues. No, they haven't, and they never will. We've never been adequately funded in any area from the Indian Act or INAC. INAC has already cut back on funding to First Nations. They do not cover all surveys, just so people are aware. And in many First Nations, they are not covering these surveys. And, we're not saying anything. They've covered some of our surveys, not all of them. We still have citizens who pay for their own surveys. And when it comes to the legal issue or the environmental issues, they don't cover all those. Environmental issues. And one example would be oil spills. We've been told that these spills are the responsibility of the CP holder. So whatever has out there, things have changed from just a year ago, from 5 years ago, from 10 years ago, from 15 years ago. It's greatly changed within the government process, and they do not fund as things that you may be aware of. They're not always funded. So I just want people to be aware of that. And again, we talked about fees. We already determined the service fees. And those fees are for the lessees. I don't think it's Hiawatha's responsibility to pay for lessees' service fees. And we've done that for years. And we have determined this fee for years. INAC will provide band support dollars. It's annualized funding. Again, that was already touched on, but part of the notes that I had. They, again, at any of our program, we're all 1 year to 5 year funded. It can stop at any time. It can be cut at any time in whatever area we're at. But what I want to finish with is the land code, and this isn't just about, I come from this perspective of, yes, as council, a part of the leadership in the community, but I also come from it as a citizen. This is my community too as a citizen. And it's important for me to know what I'm voting on and how confident I'm with it, because it's not just about me, or not so much just about me at this point in my life stage, but it's going to be about my children and my children's children. And so the land code is a benefit for all and not just the individual, by promoting the responsible use, development, and preservation of our land, and for our citizens now and for those 7 generations to come. So our children's children have a safe place to live and to live off of. And I think that's the important part. When we hear about, yes, we need housing and we need those pieces, and we're buying more land as we can that surrounds our community to grow that piece. But we also need to protect those areas that are where our people can use for land-based learning, where they can use for hunting, where they can use to live safely and live off of safely. And that's what is all important about protecting that land for not just today, but for those many years to come. So I'll stop there. I'll say miigwech to everyone. Thank you. And I'm glad to see so many people on and some really good questions raised. Miigwech.
Thank you, Chief Carr. And thank you, everybody, for your patience and sticking in with us today. We've gone over what we thought would be our time limit, but it was important to be able to address so many questions. I want to say thank you very much to Bill and to Beth for putting the presentation together and for presenting it to everybody here today. I think it was very helpful, and it stimulated, as you can see, a lot of conversation coming out of that. So thank you very much for that. There were still some questions that were on the chat that people had asked about, and we will get those answers out. We'll put them out on the Land Code website and get them out on the web as quickly as we can. A question was asked about the video today. We'll turn that over to Kelly Dickinson, and Kelly said that she will start the process hopefully today with Eugene and get the video posted for this on our website. This was the last in a series of community meetings that Bill and Beth had scheduled. We, I know, are looking at a couple of family meetings. Hope to be able to do those over the next week or so. We reached out to all of the family leads who were part of the CCP process. As a result of that, currently 2 families have said that they would be interested in having a family session, and we'll be setting those up as soon as we possibly can. Other than that, I think that's it for everybody. I want to thank you again all very much for taking time on your Saturday morning. I wish you well during this pandemic and during this current concerns, and ask everybody to stay safe, stay healthy, and we'll see you again here on some of these sessions or on future meetings as we discuss the land code and discuss a variety of things. Also, sorry, Chief LaRocca, thank you very much for your time, and Cass for being there to be able to be part of the conversation today and sharing your insight and your experiences. We appreciate it very much. With that, we'll say goodbye to everybody. Thank you again all very much, and please stay well.